Awesome. Well, good morning, everybody. Welcome to the County Commissioners' regular meeting for August 3rd, 2021. Appreciate you attending both in person and online. I'd like to call the meeting to order, and Commissioner Ibarra.
Here.
Commissioner Richardson. Well, good morning, everybody. Welcome to and Commissioner Gosar here. Pledge of Allegiance. If you'd stand and join me for the Pledge of Allegiance, please. That's cool. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Item 3, public hearing for Windmill Acres Subdivision SD-05-21 preliminary and final plats. Would anybody like to speak on behalf of or in opposition? Sure, and then we'll go to you, Mitch, next. Come on, please. State your name, please, just so for the record.
Good morning.
Good morning.
My name is Joanne Fulton, Fulton Law Office, PC. Good morning to Chairman Gosar, Commissioner Ibarra, and Commissioner Richardson. It is not my intent to belabor the issues here before the board today, but I think some background and basic knowledge will help lay a foundation for both you in your understanding of the issues and also your ability to make an appropriate decision. First, I'll give a historical context. Second, a historical legal access review. Third, a small education, brief education on easement law, what you can look to and rely on as evidence of legal access. Fourth, I'd like to address the city denial letter and the change in law of July 1st, 2021 regarding this board's authority to deny based on a comprehensive plan of development dated 2007. Fifth, I'll talk about the impact, if any, of Wyoming Statute 3412-103 vis-a-vis the law change effective July 1st, 2021. Sixth, I'll talk about the required improvements to Carolyn Lane per Albany County Regulation 4, Section 6, small subdivision process. Seventh, I'll talk about the required road maintenance agreement versus Mr. Edwards' disingenuous comments in his letter to the county commissioners dated 16/2021. And finally, in conclusion, I will respectfully ask this board to approve the Windmill subdivision, Windmill Acres subdivision. With that said, Ms. Bacon, Mr. and Mrs. Bacon, Robert and Carol filed an application in April of 2020. The Planning and Zoning Commission met on July 8th, 2020 and passed that action on to this board for review. The Albany County Commissioners at that time met on July 21st, 2020 at 9:30 in the morning. The Windmill Acres subdivision was item 24 on their agenda for that day. Following a review of the staff report, the recommendations of the Planning and Zoning Commissioners, this board voted to and made findings of fact and conclusions of law. And a roll call showed Commissioner Richardson and Commissioner Jones, who is no longer a county commissioner, were ayes. Mr. Gosar was the lone nay. I hope to answer and help you to better understand and try to understand your position as well as to that nay on that day in July or August 21st, 2020. On August 21st, 2020, Mr. Edwards filed an appeal with the district court. The reason for his appeal was, and the only reason in the appeal, was that the Board of Commissioners had not had a discussion on legal access for this subdivision. I have provided, and I believe it's part of your materials, a copy of the stipulated order reversing and remanding this particular application back to the County Board of Commissioners here in Albany County. Judge Cricken made several findings, but specifically, she says, the applicant did not provide and the Board of County Commissioners did not review or make any findings regarding whether the required legal access connecting a public road to and from the proposed subdivision exists. It is clear from the record that the only issue on appeal was the legal access. I do not believe, after review, research, and studying this situation for almost 10 months now, that legal access was ever a viable issue. And I believe that is the only issue Carol Bacon should have to address in any new proceedings, which is where we are today. All other issues, based on findings of fact, based on conclusions of law, based on an appeal by Mr. Edwards to the district court, were resolved in the first proceedings. All other issues were consistent with Wyoming statute and Albany County regulations. It seems patently unfair to now have to relitigate matters that were previously approved, not raised on appeal, especially when all other matters of concern were adequately addressed in prior meetings. Just one further comment regarding the district court action. There was an appeal filed the 21st of August. Ms. Bacon's counsel of record, Jody Shea from Pinson McMillan, represented her at that time. It's unclear to me why Ms. Shea did not do a motion to intervene. It's also unclear to me, and I have no understanding of why Ms. Shea was terminated. I do know that I was retained by Ms. Bacon on October 1st, 2020. And Ms. Shea was relieved of her representation duties. I prepared and filed a motion to intervene in the district court on November 2nd. The city of Laramie filed their response on November 12th, 2020, making the matter a contested issue. That means in legalese, a matter that a court, a judge, would have to resolve before taking any action in the case. While there is a stipulated order that you have in front of you, Ms. Bacon was not a party to that stipulation. I had met with Mr. Edwards and with Ms. Trent regarding this particular appeal and knew that there was going to be a stipulation, but Ms. Bacon was not a party to that stipulation, thus the reason for the motion to intervene. Ms. Bacon did not have an opportunity to weigh in on the appeal, and the purpose was for the motion to intervene was to give her that voice, an opportunity to be heard on the issues and to further describe and limit the issues on remand. As it turns out, the district court remanded back. The only issue was legal access. However, Ms. Bacon has had to go through 2 meetings now. She had to go back in front of planning and zoning, and then she's now having to appear in front of you again. In my view, my legal opinion, she should have just been remanded back to this board for further evidence, findings of fact, and conclusions of law on the legal access issue. I am happy to address any questions or concerns you might have at this point regarding the historical context.
I'm sure there's any questions.
If none, moving on, let's talk about the legal access issue. H.O. McConnell in 1952 purchased 4 lots from Cathedral Home for Children. Those would be lots 5, 6, 7, and 8. For 20 years, that property was undeveloped. 20 years, it sat out there. And in 1971, almost 20 years later, H.O. McConnell surveyed, platted smaller parcels in lots 6, 7, and 8. I believe that's an error. It's 6. I mean, 7, it's just 7 and 8. In 1972, which is a pivotal year for determination, H.O. McConnell's intent regarding legal access for lots 5, 6, and 7. 5, 6, and 7, a portion of 7, are the lots that ultimately belonged to Robert and Carol Bacon. These were the lots that H.O. McConnell reserved for his family, ultimately his 2 daughters. In fact, Carrie Lynn Lane is named after his daughters. He designed, developed, and built that access road into the properties, giving those first 6 lots, those first 6 parcels for sale, while reserving access to his larger portion of land at the top of Carrie Lynn Lane. Important to note that the decision to subdivide to sell off parcels did not in any way interfere or terminate the continuing legal access to the remaining larger portion of the original property. H.O. McConnell reserved for his family's use and enjoyment. Just a quick note about easement. Definition of easement. I've lived a long life and had very little contact or understanding about what easements were until this case came across my desk. An easement is the legal right of a non-owner to use a specific part of another person's land for specific use. In this case, H.O. McConnell's family to access their own remaining properties. He developed and sold off the 6 parcels, but he reserved access as a non-owner to access his property at the top of Carrie Lynn Lane, which is a private road. After the 6 parcels were sold, in lots 7 and 8, H.O. McConnell reserved an easement over the private road of Carrie Lynn. May I have a moment to get a drink? In subdivisions, easements in the subdivision declaration of protective covenants are what provide homeowners with the rights to use the subdivision's common areas. Specifically, it's designed specifically for access over private roads, in this case, Carrie Lynn Lane. I have read Mr. Edwards' letter to the commissioner and would make this comment. He cites, and I quote from his letter, Ms. Bacon is proposing to use our client's private road across their respective properties to access their proposed subdivision. Quite the contrary. Ms. Bacon plans to utilize the easement she maintains as the dominant estate in a way that is consistent with the intent of the original easement, providing access from a public road known as Vista to her property located in lots 5, 6, and 7. Often, the purpose of an easement is for ingress, egress. The need for ingress, egress comes when a parcel of land does not adjoin a public road. That's the situation. In this case, H.O. McConnell's property did not adjoin the public road of Vista based on his survey and his platting and ultimately the sale of lots 5 or 7 and 8, subdivided into 6 separate parcels. It's a simple concept. Easements exist for the benefit of adjoining land. The property, which is benefited by the easement and for which the easement was created, is the dominant estate. That's H.O. McConnell. He had the dominant estate. From the time he purchased the property in 1952 and continuing until it was later transferred to the Bacons in 1989, 1993, respectively, there were 2 purchases. No question, the intent of H.O. McConnell and his family members was to continue recorded easements contained in prior family transfers. So to be clear, Bacon has the dominant estate, while Montgomery et al. Have a servient state. What is a servient state? That was a new concept for me. Servient estate, in this case, are the smaller parcels subdivided in lots 7 and 8 and sold by H.O. McConnell. He always reserved the necessary easement to access his property in lots 5, 6, and 7 over the private road Carrie Lynn Lane. It should be noted that the sale of servient estate does not terminate the appurtenant easement. That means however many times the 6 parcels have been sold and resold, makes no difference. The easement continues. Despite the need conveying the servient estate, not mentioning the easement. What I'm saying is that the fact that later deeds did not contain the easement does not terminate the existing easement that dates back to the 1971 deeds that were making transfers. Over time, some of the parcels were sold to different individuals, and it is possible their deeds did not contain the reserved easement. However, it does not terminate the original easement created and granted by H.O. McConnell. The easement rights cannot be exercised over the entire servient estate, just in the area described in the easement. In this case, Carrie Lynn Lane is to access H.O. McConnell's personal properties in 5, 6, and 7. The easement was designed in such a way to provide continuous legal access, a point of access, which is consistent with Wyoming law, by identifying a contiguity relationship between lot 7 and all of lots 5 and 6. You will note on the maps provided, and I can point you to those maps if you would like to look at them, Bacon property overlaps into lot 7 to maintain that contiguity requirement. The cases in Wyoming, whether an easement exists, have relied on critical factors. And one of the most important critical factors is the party's intent, identified by the manner in which the right was created, the nature of the right created, the duration of the right created, the amount of consideration given for the right, and whether there is a reservation of power to revoke. Following the critical test, H.O. McConnell fully intended for the easement to continue into perpetuity. His intent was for his daughters to live in the property that it belongs to Mary Ivanhoff now, and to the Bacons, who now occupy the remaining portion where Carrie, his daughter, lived, his other daughter. In a footnote 5 of Seven Lakes Development Company, which is the Wyoming Supreme Court in 2007, I believe, the court noted that the servient owner, Montgomery et al., had no power to abandon the rights of dominant estate owners, and Bacon is the dominant estate owner. It is Ms. Bacon's position that she holds, continues to be the dominant estate, and that the servient estate has no power to abandon the dominant estate's easements for rights of access. you have any questions regarding the materials I've covered at this point? I know it's heavy on the legal side, but I think it's important for the record to contain these explanations so that we are all on the same page with this case.
Easily understood.
Thank you. Going on, the creation of an easement. How is an easement created? Because that's been an issue. Is there actually an easement that was created? An easement is created in one of three ways. Express creation, creation by prescription, or operation of law. In the H.O. McConnell case, the easement was expressly created by a specific grant by reservation in a deed, conveying property, and also on the face of the plat for the 6 parcels. That is important to note. In the application before you, the Windmill Acres subdivision, an easement has been surveyed and granted and is recorded on the face of the final plat that you have already reviewed at least once. When recorded, it becomes legal access. There are no particular words necessary to constitute a grant of easement. Obviously, using unambiguous language is important. Expressing in particular characteristics, the easement is best. And that is exactly what H.O. McConnell did. He didn't want to gamble with his daughter's future. He didn't want to gamble that at some point Mr. Montgomery would show up with other neighbors and say that they didn't have legal access. The intent of the parties is a major focus in the state of Wyoming. It's hard to imagine where Mr. H.O. McConnell would draft documents, survey, plat, subdivide, and not intend to provide ingress egress over Carrie Lynn Lane, a private road. I want to discuss briefly the City of Laramie denial letter. There was some discussion about that. I sat through the Ivanhoff hearing not too long ago, and I'm aware of some of the concerns that that you as commissioners have regarding approving subdivisions that don't meet certain criteria within the city's comprehensive plan. I want to point out to this commission, not just my case, but other cases that come before you, that the city letter is somewhat of a form letter. If you look at our letter, and I've looked at a number of them, it's identified by one caption line, a line. It says Windmill Acres Subdivision. Subdivision is not mentioned again throughout the entire city letter. In fact, the letter is so broad and all-encompassing that there is a short discussion of expansion at the Laramie Airport. Such expansion would not be negatively impacted by the approval of Windmill Acres subdivision. The letter goes on through a number of vague, poorly articulated scenarios regarding certain city plans for urban development. It should be noted that on the city maps for their comprehensive development plan dated 2007, that Carrie Lynn Lane County suburban residential area is bordered by urban residential development. Those two are consistent, not inconsistent. The fact that they're consistent means there cannot be a negative impact to the city of Laramie so long as the county is consistent with their zoning. Certainly not inconsistent. There's not been an updated comprehensive plan since 2007, a period of 14 years. And I might add, agreed to by any county personnel. The big and only legitimate concern with the city was the 30th Street exchange. Ms. Bacon is well aware of that exchange. Her property has been surveyed by the state. I've personally been out there and walked the state survey stakes. The property, and she knows that her lot 3 of the subdivision is can never be developed. Never. She's aware of that. Some 24 acres will need to be set over for the exchange development project. Ms. Bacon is prepared to provide this board assurances that she has no plans to sell, develop, or otherwise use that section of her land. Ms. Bacon is willing to provide a restrictive clause and/or deed indicating the same. All Mrs. Bacon wants from this Board of County Commissioners is what she's entitled to. As a Wyoming, albeit Albany County property owner. Further, the Albany County Regulations, Chapter 2, titled Definition, Section 3, specifically defines cul-de-sac. It defines a cul-de-sac as a short, dead-end street terminating in a turnaround area. The final plat that you've had an opportunity to review shows such a cul-de-sac between lots 1 and 2, terminating Carrie Lynn Lane, providing no access through to Corthell over the 23 or 24 acres that exist and the remaining lot 3. There will be no through traffic from Corthell or the 30th Street exchanged plan by the state of Wyoming Department of Transportation based on that cul-de-sac. This plan specifically limits further development of Carrie Lynn Lane and provides some insulation from any thought of city annexation. It should also be noted that after a conversation with the city attorney, Bob Southard, he shared the city of Laramie, shared with me, city of Laramie has never in its history engaged in a taking of property for city annexation. Individual citizens have initiated annexation discussions and voluntarily been annexed rather than their property taken. I also investigated the feasibility of whether or not this Carrie Lynn Lane area could be annexed, where the connections were for water and sewer. There is water on the downside of the hill that runs toward Vista, and it's about 1,000 feet off of the property lines. The sewer line can't be attached there because sewage has to run downhill. It has to run down and it would be connected somewhere past Corthell or on Corthell, but somewhere in the neighborhood of the 30th Street exchange. Again, not feasible money-wise, not feasible city annexation-wise. To be clear, the city failed to identify a single negative impact with specificity. And clearly, the suggestions in the 2007 comprehensive plan have not been incorporated into the local zoning regulations, whether city or county. With that addressed, I want to turn now to Wyoming Statute 34-12-103. And again, I would reiterate, I was present a few weeks ago when you reviewed and denied the Ivanhoe subdivision, relying on specifically 34-12-103 IB. Since that time, the Wyoming law has changed, in my view, making that denial suspect. The statute was not intended to be used to deny legitimate applications for small subdivisions. It is clear from the hearing I attended that at best, the findings made as a board were inadequate and incomplete. For instance, 34-12-103. There are 5 categories. They're not pick one and fly with it. There's a semicolon, and you get through all 4 semicolons, and then there's an and. It's a conjunctive. You as a board, we're required to make individual findings for each of those provisions in order to deny the Ivanhoff application. I am addressing that today, not in defense of Ivanhoff, but in defense of my client, Carol. I don't want her to fall into the same kind of inadequate, incomplete record. Each subclause, I through V, again, is connected with a semicolon. And when you get to IV, at the end of that clause is an and. It should be noted that for the most part, each and every one of these variables are not required under county regulations for small subdivisions. I don't know if you've reviewed the small subdivision language recently. I will cover that here in a moment. But at first, I want to note that the law did change in July 2021. 98301, nothing in this article shall allow any local government to use a local land use plan as authority to deny or restrict a permissible land use or physical development, which is not restricted or prohibited under existing zoning regulations. And those zoning regulations have not incorporated the things that you found or that you potentially could find. 18, there are a number of statutes that changed. The one I want to point out is Wyoming Statute 18.5.201, authority vested in county commissioners, states in relevant part. No board of county commissioners shall require that a land use or physical development be consistent with a local land use plan unless the applicable provisions of the local land use plan have been incorporated. And I know I'm repeating myself, but I think it's important to realize unless these provisions are incorporated into local zoning regulations, you have no power to deny an application.
Ms. Fulton, I hate to interrupt you, but how much more time do you need just from a scheduling perspective?
I'm nearing the end.
Okay, so would you say 5 minutes?
More like 10 or 15.
Okay, thank you.
Let's talk about 3412-103, the improvements to Caryland Lane. Albany County Regulation IV, Section 6, subdivision process, which is what I indicated I was going to talk to you about, says a small subdivision, 3 or less parcels, and less than 35 acres. There is a 5, a 10, and then a larger lot 3 that is not in play on the Windmill acre subdivision. It is intended that the regulations within this section, and I'm quoting from your regulations, provide a less costly method to develop small subdivisions and yet retain basic protections to the public. B, if a proposed subdivision qualifies as a small subdivision, the following state and county regulatory provisions will not be required. Goes through a list, a report from the a Wyoming registered geologist, proof of published notice, a review and recommendation from local conservation, a review and recommendation from the Wyoming Department of Environmental Quality, fire safety facilities, not required. Public access road, right-of-way, minimum width of 80 feet and minimum road bed 24, not required. What is required is a road right-of-way that shall be a minimum of 50 feet and an all-weather road bed width of 16 feet shall be required. The applicant has a bid. She has provided the city or the county with a letter of credit to pay for that work, and it has to meet code, has to be inspected and meet code prior to her being cleared under the county regulations. And that letter of credit will be on hold unless or until those requirements meet the county regs for the road. There's also some discussion in the Planning and Zoning staff report, and Mr. Edwards raised concerns that Carrie Lynn Lane did not meet certain county road requirements. In response, Mr. Gertch in his staff report cited platting and subdivision regulations. I would first challenge whether or not this section, this chapter, even applies to a small subdivision. And I would ask you to take a close look at that. I would argue that this section does not expressly apply. And it's found at, I cite the 50 feet and the 16 feet requirement. To bring this issue up now, and this is it is a new issue, which is outside the scope of the original application, the original review before the planning and zoning, and certainly before this board. In essence, what I'm saying is that issue is a res judicata. It was reviewed, it was looked at, there were findings of fact, there was approval, and it was moved on. The only issue that did not meet muster with the district court appeal was the legal access. In my view, you don't have a right or the authority to review this particular issue. Ms. Bacon is prepared to meet the requirement within the subdivision, the entrance to the subdivision. But what she would say is she's prepared to meet this burden for the subdivision access, but the road outside her access is a neighborhood issue and has existed, this is the kicker here, has existed since 1989, 93, when the Bacons purchased their property. It wasn't an issue when they bought, and it shouldn't be an issue now. They've done nothing to require this board to make them improve or do anything to the road that existed at the time they purchased. This should not rest solely with Ms. Bacon since it existed. Ms. Bacon is happy to meet and develop a plan for all of the property owners along Carrie Lynn to develop a plan that would improve the road as a unit. Nor should Ms. Bacon's application be denied on the basis of this road issue. It's through no fault of her own. Ms. Bacon, that the road was grandfathered in its present condition. She's being asked to fix something that has existed for 30 plus years. And if you make that a condition of approval, that is punitive on this landowner. Mr. Edwards, in his letter to the commissioner, states, Ms. Bacon has not entered into a road maintenance agreement or, for that matter, engaged in good faith negotiations to obtain a road maintenance agreement. This is a disingenuous statement. A draft of a road maintenance agreement was mailed to each of the neighbors along Carrie Lynn Lane, and that was done by Jody Shea. She received no response. What happened is Mr. Montgomery et al. Filed the appeal to the district court, failing to respond completely to a road that they are required to maintain. When I came on board, there were at least 2 more road maintenance agreements mailed out. No response. So to say that the one response was David and Belinda Bacon, but to say that Ms. Bacon has failed in some way to try to obtain a road maintenance agreement is patently disingenuous. There can be no dialogue with people who fail to respond. What this Board of Commissioners should be aware of is that from 1989, Robert Bacon by himself maintained this road for all of the residents until he moved to Michigan. He didn't get paid to do that. He used his own equipment. He maintained that road, rain, summer, winter, snow. In more recent years, when Mr. Bacon's health began to fail, Mr. Montgomery began assisting Mr. Bacon with road maintenance. and then took over the responsibilities. One might wonder, what is Mr. Montgomery's interest, and or for that matter, the other landowner's interest in opposing the Windmill Acres subdivision? Certainly not a burden on the existing servient estate. I'm aware that prior to the development of the family subdivision, Robert and Carol offered to sell their property entirely, all of the acres, all of lots 5, 6, and part of 7 to Mr. Montgomery. My understanding is Mr. Montgomery thought the asking price was too high. So now we come to approval of this application for a second time. Mr. Montgomery, even with documentation of legal access, continues his opposition. Why? Ms. Bacon has been asking the same question. She thought she was friends with her neighbors. She had good working relationships. Bob and Mr. Montgomery were friends, and they worked on the roads together. All Ms. Bacon wants is what she's entitled to as an Albany County, state of Wyoming property owner. If the true nature of this neighborhood is to protect it from through or increased traffic or even city annexation, Ms. Bacon has satisfied that concern, and the objection should be resolved with the safeguards she has put in place. In conclusion, it is clear that Robert Bacon, prior to his demise, and now Carol Bacon have completed and met all Albany County requirements, city concerns, and neighborhood concerns relative to increased traffic. Through no fault of the Bacons, this project has been delayed for over a year. First, by the Albany County Commissioner's failure to make appropriate findings related to legal access. The matter could have been tabled by this Board of Commissioners, resolved, and moved forward. That did not happen. Instead, second, by an unnecessary appeal to the Albany County District Court, to which Ms. Bacon was not allowed to be a party. Third, in an abundance of caution on Ms. Bacon's part, 2 independent reviews were done by First American Title Insurance Company to determine the legal access question. Fourth, the length and elongated process of getting the application resubmitted for review and approval by both the Albany County Board of Planning and Zoning based on the district court's order to remand the matter to both when the only issue is legal access. And now here we are again with all the I's dotted and T's crossed, asking you as commissioners to approve the Windmill Acres subdivision so that Ms. Bacon can begin to heal emotionally from the loss of her husband this last year, recover from the financial impact since starting the small subdivision process, and the stress it has caused her family and herself. Through no fault of her own, she did nothing except do what you asked of her, do what the statutes required, did what the regulations for the county required, doing everything that was asked of her. On behalf of Carol Bacon, I respectfully ask this Board of County Commissioners to approve the Windmill Acres subdivision. Thank you.
Thank you, Ms. Fulton. Mitch, I think you would be next.
Thank you, Mr. Chairman, members of the commission. My name is Mitch Edwards. I'm with the law firm of Nicholas and Tangeman. I represent 9 different landowners that I've identified for you in our letter. Just wanted to let you know that those 9 landowners are all the landowners along Kerry Lynn Lane whose property rights are affected by this application. The only person who's along Kerry Lynn Lane that is not part of the opposition to this is Ms. Ivanoff, who actually proposed her own subdivision on this property that was denied. I do not want to belabor it all. We're here to pose the subdivision based on the adequate legal access issue. I've outlined that for you. One, we don't believe that they have appropriate legal access at all. when you look at those documents, there is not a reservation at all for lots, government lots 5 and 6. To the extent that one could consider that there may be a reservation, it's for government lots 7 and 8, which is not where this subdivision is located. If Mr. O'Connell had intended to reserve an access across property that he sold, the way to do so is indeed to say specifically that I convey to you this lot and I reserve across this lot access, an easement for myself for this property, government lots 5 and 6, to cross your property. That has never happened. And you do not see that in any of the documents that were provided to you. I could get into a bunch of the different aspects of easement law, and I'm not going to do that for you, but we don't believe that any of that has been met. Regardless, even if this body was to consider that there is legal access, your regulations require that legal access to be at a minimum for a small subdivision 50 feet wide. The documents that were provided to you show a maximum width of a road right away of 40 feet. That's 10 feet short of the required minimum that your regulations require in order to have a small subdivision. Now, in addition to that, if the subdivision is within 1 mile of the city limits, the legislature has specific statutes that require the board to make findings. And Ms. Fulton identified that there's 5 findings. Those findings are not to deny a subdivision, but are to approve a subdivision. 2 of those have to deal with proper access. In regard to that statute, this body has adopted a regulation that requires that if a proposed subdivision, regardless of whether it's a small lot or a large lot subdivision, is within 1 mile of city limits, it has to comply with city roadway standards, including roadway widths, curb and gutter, paving, and all of those other issues. Because this subdivision fits within that 1 mile buffer, it is required by your regulations to meet those requirements. And not only is the roads within the subdivision required to meet those requirements, but your regulations provide if they are going to cross others' property, that they are required to improve that access crossing others' property to a public road to the same standards that they are required to develop the roads within the subdivision. Meaning that even if Ms. Bacon had legal access to governmental lots 5 and 6 for her subdivision, it would have to be at least 60 feet wide, have 46 feet of paved curb and gutter in order for this board to approve the subdivision. And that just can't happen, and it won't happen. All the other stuff is ancillary to this issue. Our clients are here to protect their interests with respect to the subdivision. Ms. Bacon is asking for a subdivision permit to subdivide her property to create more lots. And she's required to comply with the regulations that are in effect at the time of her application. And these are those requirements, and she has not met them. And so we would ask that you deny the subdivision based on the failure to meet the minimum standards that the board is required for legal access and roadway width and standards for development of those roads. Thank you.
Thank you, Mr. Edwards. Is there anybody else in the room here who would like to speak in the public hearing?
I would.
Please.
Hi, I'm Melinda Bacon.
Could you please come to the microphone, please? Thank you.
I didn't prepare anything for this.
That's all right.
I just, after listening to Mr. Edwards.
It's better when you don't.
No, I just feel like I just want to say that I own the property at the top. I'm Belinda Bacon. My husband is David Bacon, and we have no intent to increase traffic in any way. We don't want more traffic going through our property as well. And so we would like to address that, and just to say that we're happy to work with anybody to work with us. Not one person on that road came and talked to us. I went and made contact with Mr. Edwards, and he outright lied to me. So that's all I would like to say for the record.
Just for the record, I would correct that it's not Mr. Edwards, she was Mcgregor. Mcgregor, sorry.
Sorry. So I know I'm emotional, but it's been 2 years,
Yeah. Would you like to speak? Is that why you raised your hand?
Yeah.
Okay, please. Hey, could you make all your comments to the chair, please? That would be great.
I'm Loretta Prater. I'm the one that's actually trying to buy one of the lots of the subdivision. And it's been a long process and we're not trying to cause traffic or anything. I'm sorry. But we're just trying to live our life the best we can. And we don't want to cause any harm. We don't want any, we moved out here just to have privacy and not have a bunch of traffic. So that's all we're trying to do. That's all. Okay, I'm sorry.
No worries.
Thank you.
Anybody else here would like to make public comment? How about online? Is there everybody online that would like to make a public comment for Windmill Acres Subdivision SD 0521 preliminary and final plats? Commissioners, I'd entertain a motion to close that public hearing.
I move we close the public hearing.
Second.
Moved and seconded. Any further discussion? Sir, did you need to make a comment? Okay. No, I just saw you moving and I didn't want to. Okay. Been moved and seconded. Hearing and seeing no further comments. All those in favor signify by saying aye. Please.
Aye.
Aye.
Aye. All those opposed, same sign. Motion carries. The public hearing is closed. Item 4, comments from the public. Are there any comments from the public here in the room physically? How about online? Are there other public comments online? You can just raise your hand or you can just unmute yourself. Commissioners, entertain a motion to close public comment, please.
I so move.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye.
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 Aye, all those opposed, same sign. Motion carries. Disclosures, Commissioner Barra, any disclosures?
I have none.
Commissioner Richardson, any disclosures?
I have none.
And I have none also. Item 6, consideration of changes on the agenda. Sheriff Appelhines, good morning.
Morning, Commissioners. Considerations for changing of the agenda. I would like to remove item 17. Contract has been sent to Core Health, but we have not gotten a response back to the changes that we've made. So I'd like to push it to the next meeting if that's acceptable.
Thank you, Sheriff. Jackie, would you make that so that I don't forget? Thank you. So item 17 is removed. Any other changes to the agenda? All right. Item 7, approval of the consent agenda. I'd entertain a motion or a move of anything from the consent agenda. What is your pleasure?
I move that we approve the consent agenda as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye.
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 Aye, all those opposed, same sign. That motion carries. Item 8. On the regular agenda, present for approval, application for catering permit for Calverman Steakhouse for a wedding ceremony and reception at Fiddle Ranch, 84 Fiddle Ranch Road, Laramie, Wyoming, 82070 on August 7, 2021 from 4 p.m. to 12 p.m. Kayla.
Good morning, Commissioners and Chairperson Gosar, Commissioners, excuse me. I am presenting a catering permit for Calverman Steakhouse. It has been reviewed by the attorney and by the sheriff with no issues. Everything looks to be in order.
Commissioners, any questions?
None for me.
Did they intend that to be 12 a.m.?
Oh, I didn't put that on there. I'm sorry.
Or is it to the following day that they want to 12 p.m.?
I'm assuming it's probably 12
We're gonna party all night.
Yeah.
That's a
a.m.
wedding.
Literally all night. AM. Yeah, so we
Okay.
make that correction. Sorry about that.
No worries. I'd entertain a motion for item 8, please.
Mr. Chair, I move that we approve the application for catering permit for Calverman Steakhouse.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye.
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 Aye, all those opposed, same sign. That motion carries. Item 9, present for approval. Application for catering permit for Waikolo for Waiko VFD Annual Chili Cook-Off and Fundraiser at Waikolo Lodge LLC, 3987 Wyoming State Highway 230, Laramie, Wyoming 82070 on August 14th, 2021, from 7 a.m. to 7 p.m. Kayla. Thanks.
Commissioners, this is the annual chili cook-off that they have up at Waikolo. It's been reviewed by Jennifer and by the sheriff with no issues.
Commissioners, any questions? Entertain a motion for item number 9, please.
I move we approve item 9 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye.
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 Aye, all those opposed, same sign. That motion carries. Thank you, Kayla.
Thank you.
Item 10, present for consideration the Windmill Acres subdivision application SV-01-21 preliminary and final plats and a subdivision permit. David.
Yeah, Mr. Chairman, Commissioners, I will forego the history of this project because I think we've got that outlined pretty well by Ms. Fulton. She did a very good job of outlining where this came from and where we're at today. The one comment I would make on the comments from Ms. Fulton was she did mention that we should only be looking at access because that was what they discussed. However, in the stipulated order, it did basically vacate the plat. So it's of null in effect. There's no plat. It's not on record anymore. And it did remand it back for planning and zoning, the Board of County Commissioners for further review. So during that time, we've had a lot of things happen, right? We have a new commission member. We have 2 new planning and zoning members. We have a different staff person that's assigned to this project because the other one is no longer with our office. So there's a lot of things that are going on. And so I will let you know that as we went through and reviewed this, we reviewed it like it was a new subdivision. We looked for everything that we needed to look for.
That's not very nice.
Just out the door to the right, please.
Look what happened.
What's up?
Dessert.
No, we don't get it exactly on.
That was a nice fresh air.
I know,
Right?
kind of appreciated that.
Hey, how
A
are you?
little fresh air busy, but it's all good.
Did you hear that our evac point, we're supposed to go to the detention center lobby?
I did.
We
Looks like you'll be doing
Just
it
stay there.
again.
They can book them and stay there.
Did we know that before, Jennifer?
No, Kurt didn't, I didn't.
I didn't-
Beeson's like, it's been your evacuation, but we're like, oh, sorry, we'll go next
I
time.
don't think I've ever, in all the years I've been a commissioner, the fire alarm has never gone off. That is the
I've
first
been
time.
here when it's gone off, but usually Roy shuts, or when they're testing it, Roy will send a message and then shuts it right back
Right.
off.
Well, sure, like that,
Yeah,
like for 5
But-
seconds.
yeah, but not like actual,
To make it make sound
yeah.
or something.
Jackie, whenever you're ready. And we're. Right. Are we ready to go?
Is the recording back up?
All right, David, looks like we're recording and Jackie's ready to go.
Okay, sounds good.
You're on board again.
All right,
Thank
so I was just talking to you about how we did a thorough review of this application. And I also wanted to mention that the applicant and the applicant's representative, Ms. Fulton, have worked well with our office and they have provided everything that I've asked for as we went through this process. So just didn't want to leave that out as well. So with that, I'll go through my staff report. So the access to this site is from Carryland Lane, as has been discussed. And we went over the district court ruling and how this is back to you again. Game and Fish reviewed this, just noted some comments about potential fencing and landscaping concerns. Mr. Todd Feeser from the Assistant City Manager provided comments, and those are provided in the packet. And I'd be happy to go through those with you if you have a desire after my staff report. Bill Gorman at the time reviewed this application, and all his concerns were addressed. Whiteout reviewed this. They just commented on the potential concerns with the future 30th Street interchange, and they provided some comments which are attached as well. The comprehensive plan shows this as in priority growth area 1. This major street plan is also comes into play. The interchange will be located on the western part of this property. Water and sewer will be on-site water or wells and on-site septic systems. Access, so this has been something that's been discussed, and the reason this went to district court basically was the access issue. We have received additional information from the applicant, and we had a good review of it today by Ms. Fulton. The county attorney's office also has found that legal access is adequate for this project. So the roads, so Carryland Lane is a private road and it comes off of Vista Drive. And just for your edification, I did go out and do some measurements on the roads. So the roads where it comes off of Vista Drive, it's about 22 feet wide, which is way above the 16-foot standard that we have for our small subdivisions. And going down the road, it does taper. You get to a point where it does get about 10 feet wide, so it's doesn't meet that 16-foot standard. But it does provide, I mean, it's been there forever. It does cross private land with the easement across it. And so that's what they're using to get there. Once they get to there's a couple of properties right before the proposed subdivision, there will be a road that's built to the 50-foot standard across there. as part of this subdivision application, and there'll be a cul-de-sac that ends on the applicant's property. Let's see, road maintenance, they have attempted, so there will be road maintenance for the road that that they will build across the properties near their application, or what the property is being reviewed right now. And they have provided some covenants with which will need to be a road maintenance agreement covenants they'll need to be filed if this is approved with the clerk's office. Financial assurance was provided as well for that. And with the rest of the road that's privately maintained and owned, that road, they did, as was discussed, they did send the road maintenance agreement to the property owners, and there hasn't been any responses for that. Our regulations require that reasonable efforts are made to come into a road maintenance agreement. And one of the options is to try to communicate in that way and come up with a road maintenance agreement with the property owners that maintain the road. And if that's the documentation they provided, they have sent those the request to the landowners to come into a maintenance agreement with them, but the other landowners, obviously they've hired an attorney, are not interested in that. So so there has been no discussion between the two parties on that. So fire protection, this is a 3-lot subdivision, and fire warden has waived fire safety requirements for subdivisions of 3 lots or less. And notice was provided as required. Findings of fact are incorporated herein as the findings, the information provided in the staff report are incorporated herein as findings of fact. Conclusions of law, the applicant is proceeding in accordance with the requirements of the Albany County Platting and Subdivision Regulations, chapters 1 through 8, appendix A for preliminary and final plat. Just my analysis in addition to what I've already said. So the proposal is consistent with the development of the existing area. There's lots that range from 1.26 acres in size to 9.14 acres in size. The proposal that you're looking at will create 2 5-acre parcels and I believe it's a 24-acre parcel. So, and let's see. The city of Laramie did provide comments, and all of their comments are addressed in a draft letter that was provided by staff. Just to note that the existing residential lots, the future location of 30th Street Interchange in this area, as well as I-80, will curtail any additional development in this area by the city. So annexation doesn't seem to be ripe at this time, or even needed this time because of the development that's already occurred. The 30th Street Interchange will impact this development, and I think this is probably one of the biggest issues for the city and the county, is just to make sure that the 30th Street Interchange can be developed in the future, if that's what YDOT decides to do. YDOT really didn't give us a whole lot to go from with their recommendation. They just basically gave us an overlay of what another intersection looks like, and they overlaid that on the property. That bigger lot should be able to handle the additional or the interchange there. And with that, the applicant has put a note on the plat that will require any development on that lot to go through YDOT first. And so YDOT will have to give their blessing in order to go forward with anything. But the applicant's intent is to, I believe, leave that space for development in the future. Financial assurance was provided, like I said. So I think everything else has kind of been covered. Planning and zoning did make a motion and discussion They made a motion to certify approval of the Board of County, to the Board of County Commissioners, the application with the findings that legal access exists to the proposed subdivision. Mr. Hinckley was concerned with the city's letter and wanted to discuss the county's view of the letter, and that draft wasn't provided in the packet. That got omitted somehow. We didn't get that to them to review. However, that's a portion of the statutes that basically says the Board of County Commissioners need to address the city's letter, and so that wasn't provided at that time. Mr. Kennedy pointed out we cannot base a decision on a comprehensive plan. Ms. Hanning would like to see development around the city to be in compliance with how the city grows, but understands that the land use plans are considered policy and do not have a force and effective law. Mr. Moore has provided the required, or provided, Mr. Moore just noted that they provided the required information and comment that we may look into the road standard issues in the future. And a vote was taken. Mr. Spiegel and Mr. Kennedy and Ms. Hanning and Mr. Moore voted in favor of the motion, and Mr. Hinckley voted against the motion. And the motion to approve was passed. And so their recommendation as a board is to approve this application. So this time, if you have any questions, if you'd like me to go through any of the documentation, I would be happy to do so. But that's the end of my presentation.
Thank you, David. Commissioners, if you have any questions for David.
Mr. Chairman, I'd like to make a motion and discuss.
Okay.
I move that we approve the Windmill Acres subdivision application SD 0121 preliminary and final plats. And the subdivision that goes with it, incorporating the findings of fact and conclusions of law.
Is there a second?
I'll second it just for sake of discussion.
Moved and seconded. Okay, commissioners. We'll start with you, Commissioner Ibarra, and then go to you, Commissioner Richardson.
Okay. First of all, David, I'm really disappointed that adequate information wasn't provided to the P&Z as far as the response that was written to the city's letter. I really believe that we're going to be making important decisions that affect people's lives, that we should all be dealing and provided with the same information. So, future, I'd really like to see a better attempt at getting everybody the same information. And I know that these meetings were being conducted by Zoom, so it wasn't like you could pop something up or.
I had the information there, but they didn't ask for it after that point, so.
Okay. Well,
and it was my fault. I apologize. I don't know how it got omitted. It wasn't intentional. Though,
okay.
So.
Okay. Well, I think Ms. Fulton has shown that access may be legal. I'm not sure it's adequate as far as standards. I don't often agree with Mr. Edwards, but I do believe that the small subdivision regulations, our regulations, and specifically small subdivision, section 6B6 fails to be met. There isn't a minimum of 50 feet, and there is only 40 feet, and that obviously doesn't meet our standards. You, David, said that maybe the Board of County Commissioners may consider granting a variance. A variance is an exception, basically a deviation from the official permit to do something that normally is forbidden in our regulations. And so I'm not keen on starting issuing variances so that an application may meet findings and all. So I'm not comfortable with that suggestion or consideration. You yourself have stated just in your presentation that you view this as a new application and thus look at everything again in that way, treated it as such. And so I think it's okay for us to be discussing the fact that this application doesn't meet the standards required. and not have to just stick to the legal access issue. I do believe they have legal access, but that doesn't necessarily mean it's adequate as far as standards.
Mr. Chair, may I address?
Sure.
Okay, so the 40-foot standard for that, for the right of way, that's not a standard that has to be applied to that road. The only standard is it says in our regulations that the road has to be built to the same standards as what's required in the subdivision. That's not the right of way. The road itself needs to be built that, and I did note that it does go down to 10 feet, so it doesn't meet that standard. But I don't believe that you have to have the 50-foot or right of way all across there. Because the only stipulation is for the design of the road, not the right of way.
And then I must be misinterpreting it under section B here. Sorry, section 6B, part 6, it does say, however, road right of way shall be a minimum of 50 feet.
Right.
And all weather roadbed within width of 16 feet shall be required.
That is the standard for the subdivision, not for the road that crosses other people's properties.
Okay.
Any further questions?
No, not right now.
Commissioner Richardson, please.
David,
Yes.
I'm thinking a little bit, what Commissioner Ibera said prompted some thoughts in my mind. I'm trying to sort them out. I mean, I know what I want to say. I got to think of how to say it so everybody in the room understands. The words right of way and easement get sort of used interchangeably, but they're not interchangeable. Because a right of way is deeded to the public, like the streets in Centennial are rights of way. But this is easement, so likely the private land goes to the center line of the easement width, right? So it's a access across other people's land. So I don't know if the rights of way, if those widths apply in the situation where, like, to me, I could imagine it being something like Coach's Row over here at 30th and Reynolds. It's a private access for all those homes in there, and it's not the same as Reynolds. Just like Cherry Lynn Lane is not the same as Vista Drive, right? Right. So it's kind of like a private shared driveway, if that makes sense. And so I'm failing to understand the interchangeable application of the regulations to something that would apply to a right of way that may not apply to an easement. Also, I can understand why they have to meet the width standards in their new subdivision and inside it. But I don't understand how what I would consider to be a grandfathered easement width could be used as a tool to limit somebody's use of their property. In other words, is the narrowness of that easement enough? And this is kind of legal, right? Is it enough to say, to be used as a tool, as a lever to deny the subdivision? And I don't believe that it is. I think that that's kind of backwards. Because I think that you have the subservient versus the primary estate. I think the primary estate in the in the easement process gets to have its access regardless of the technicality that is the width of the easement, which isn't the right of way. Now, when it comes to the city's comments, I was at the hearings, and I know why. At that time, it was House Bill 14. I don't know what its enrolled act is called, is numbered. But I know why it was put in place, and it was specifically put in place to limit the comments that municipalities can make. Mostly because the city of Laramie has always asserted more authority or suggested that it has more authority than it actually does. And it's really hard for an applicant or even commissioners to distinguish between suggestions and requirements, right? So I wonder if we could go through the assistant manager's letter point by point so that we can discuss the legalities of what the city is asking for, because I think it's really important to do that within the context of what the statute says. Can we do that?
That's fine with me.
Well,
Sure.
in light of the regulation and the legislation, we just have to respond, right? We don't have to, they are not regulatory to us. And so we can go through this exercise, but we don't have to, because this body does not have to take the city's comments and letter as regulation. And so unless there's some way you want to determine why we have to, I
agree with you wholeheartedly, Mr. Chairman. So that begs my question. So why did this commission take into account the city's suggestions and we gave preference to the city's, not legally binding suggestions over our own regulations? Why did we do that before? That's the reason why I want to go through it.
Yeah, well, what we did before is we approved it, and then it was remanded by the court. And so I was in opposition to that approval. And it was remanded to us by a court. So we did not follow our regulation. And that's why we're here today. To suggest otherwise is not to be accurate. Ms. Fulton.
Oh, I apologize, Mr. Chairman. I'm confusing this application with the Ivanhoff one.
Okay.
And in the Ivanhoff one, we did give the city's suggestions more consideration than our own regulations. So that one we have to think about too. So I apologize. I don't know that we have to go through that. We probably don't. I was thinking about it in a different context, the context of the other subdivision. And I do think that it applies to this one and that one. The concept of legal lanes and whose responsibility is whose. And I think that this commission struggles with that. We struggle to understand that.
My comments, Commissioner Richardson, were not anything to do with that letter from the city. I was addressing our own regulations, subdivision regulations, and in Mr. Edwards' letter. I didn't make any comment to the effect of anything the city had proposed.
That's true. That's what happened in the Ivanhoff subdivision, and I was confusing it too.
Well, we might have a different read of that.
No doubt.
So do you have any more? Because I've got a few.
Okay.
Yeah.
Well, I might again,
Okay.
but go ahead.
So I'm going to walk us back a little bit to the first couple of years here on the commission and another subdivision that was approved with incompatible roads for our emergency management. And in fact, our fire and our ambulance came to us and said, yeah, this is a very dangerous subdivision. And so let's just preface that going forward. If that road is to apply just inside the subdivision, would you suggest that any subdivision that had a goat track from the nearest public road would be approved? That we should approve that as long as it's the 50 feet and the 16 in the subdivision?
No, and that's not what I'm saying at all.
So where does that 50 feet and that 16 feet, would you suggest that begins? Where does that begin and end?
Well, and that's the question, right? That's the biggest question for me as well as your staff is is how do we address these types of things? Because the road's been there for, ever, for a long time, not ever, but like 30, 40 years, and like I said, the road is actually not bad until you get to the very end, and then it kind of, winnows down into a smaller road.
Because it's like a driveway to the last
right.
developed place.
It really is like a driveway, yeah. So we get what our regulations do say, and the right of way is one issue, but the road width is another issue. So the road width does not meet the standards when you get down to there, and that came up, and we discussed that at planning and zoning, and there wasn't really any outcome other than they approved the subdivision. So that was brought up by Mitch Edwards, or Mr. Edwards, and I agreed that, yeah, that's the truth. This is how this is. It does not meet the standards, and so that's where it becomes even more difficult, because the landowners that this prop goes over their property, they're the ones that have really the rights to do something about it, but they do not want to work with the applicant. So there's like, do we now allow all applications to be turned down because neighboring landowners don't want to work with them to improve and do some of these things? And so that's where I'm in a quandary. I think this is a big issue, and I don't know how to even address that, legally. And that is an issue that maybe we should figure out, with this application. So,
Well, for me, it makes some sense that minimum requirement would come from a public access, right? Because we're ensuring safety and health. That's our first duty as county commissioners. And if you were to suggest that that's began at the subdivision, but there was a mountain bike trail between that and public access, we couldn't guarantee that a fire truck could get there or that an ambulance could get there. And so I just don't believe that makes any sense just in the subdivision itself. I think that there needs to be some minimum requirements from public access to a subdivision. So that road, for me, doesn't meet our regulation. Right. And I just have to tell you, within the first year here, I heard about a subdivision that had blind roads, blind corners, too tight of corners for fire to feel comfortable feeling that they have service and the ability to serve in that subdivision. So I can't follow you with it. It's the new road, 16 feet, 50 feet in a new subdivision. It has to be further than that. It has to be guaranteed at least to that. And right now we don't have that guarantee. And so if we're going to approve this, for me, we would have to approve it with a variance. Would you agree with that, or would you not agree with that?
So where it doesn't meet the 16-foot standard, I would say, yeah, you probably would need a variance for that.
Mr. Chairman.
Yep, I'm done. Go ahead.
We're discussing this as though roads are permanent and that can never be changed. The width of the part that doesn't have grass on it, because there isn't a road, there's only an easement, and some of it has grass on it and some of it doesn't. There isn't a road. You can't call that a road. There's all kinds of places all over this whole county that are used as roads that, I mean, I don't know what the definition of a road is, but it probably has some development to make it a road, and that has vehicles driving over it enough that no grass can grow. So, but it's not a goat track. I would contend that the ideal of your position doesn't exist in law. Because we think that we should be able to provide good ambulance and, emergency vehicle access is not a definable legal position. It's an opinion. And we haven't codified that in our own regulations, so we can't apply it. I kind of like the rule of law because everybody knows, if you play Monopoly and somebody doesn't follow the rules, even the banker, they're not following the rules. And we have to follow the same rules we apply to developers. We don't get to make them follow the regulations and then us make up our own variations on it because we feel like it. We make the regulations and then we also implement them. And we can't implement something that we haven't made already. We have our opportunity and we have an application in front of us. And so that we could do it for the next one. But we can't do it for this one because we don't have it codified. What I would say is the width of the dirt versus the grass might be narrower than 16 feet, but that is not a permanent condition, not nearly as permanent as the applicant's right to use that right of way or that easement. The point is we can't take a temporary situation that can be remedied easily. You go out there with a belly dump and some yellow iron and you make the thing wider. That is not a sufficient legal justification to not allow someone to exercise their permanent property rights within the regulations of the county. So we have to differentiate between feelings and preferences and actual applicable law. And in this case, when fire and ambulances respond, they drive in grass, they drive wherever the hell they need to get to the angle that they need to get to. They don't say, oh my gosh, this road is 1 foot wider than our tires, and so we can't go down it and that guy has to die or the house has to burn down. They do their jobs and they do them really well. And the fact of the matter is this one is not applicable to Wild Horse. It's not comparable to Wild Horse Ranch because Wild Horse Ranch has all kinds of rises and falls and turns. And this is straight as an arrow, this little path, this little road. So if we commingle these things, we can confuse ourselves when we have a legal issue in front of us. And that is their right to access their subdivision by using Carrie Lynn Lane. The road standards are not relevant except for inside the subdivision that they're proposing. They can't be required to fix or widen the road against the will of their neighbors all the way from Vista to their edge of their property as a condition of exercising their right to their own property.
So in my mind, there's no right being taken away. A subdivision is a request. We have a law and it says 50 feet and 16 feet, 50 feet of easement and 16 feet of road. They don't meet that. And I'm sorry, they don't meet that.
Mr. Chairman, what were the width requirements and the dirt required, this road requirements 40 years ago when this thing was, now it's been 50 because it's the early 70s, right? Because when that easement was established, it might have been established under different regulations than exists today. It's pretty hard to retroactively apply today's regulations to a private road that's an easement, not a right of way. It's pretty hard to do that. That existed the way it is for 40 years. And we're going to say that we're going to limit their ability to exercise their property rights unless they force all of their neighbors to widen the width of the easement and allow them to widen the road. I mean, they're not responsible for the entire neighborhood. The neighborhood is partly responsible for the neighborhood. For somebody to use leverage like that because they're in opposition, you know, it's kind of what happened with the wind farm. When people want to assert a right that doesn't exist to stop someone else from using their property, and they want us to be their mafia enforcers, that's entirely inappropriate. When you have property rights, they extend so far, and there's a point, a legal fence, and fences are good for neighbors. There's a legal fence where a person's property rights stop and the next person's begin. And if people who say, well, I was here first, it doesn't matter if they were physically there first because the ownership is what it is, right? It's not about physical presence. It's about, and what's interesting about this is that the primary estate, I think the guy's name was McConnell, was there before all the others. So if we're going to use the I was there first thing, then that would favor the Bacons because those lots and that subdivision was there before he subdivided the stuff on the way to it. This is a really strange discussion. It's too much micromanagement.
No, I agree with that. We have a clear rule on the books and you're telling me about rule of law. That is a strange discussion. I find myself like scratching my head, quite honestly. But if you want to ask any more, I mean, our planner said that we would require a variance to approve this subdivision. That seems to me to be pretty straightforward, that we have a 50-foot easement and a 16-foot road. So, you know, I don't.
But that is not a legal opinion.
Well, I'm not a lawyer, but I can read. And so, yeah, it's not a legal opinion.
No, I mean, you're saying that you asked him, but that his is not a legal opinion.
Nobody's a professional. We hired him for his opinion.
Well, why don't we get a legal one?
Okay. Yeah, sure. Jennifer, would you like to weigh in on this?
Mr. Chair, I just want to point something out. David did say, and when you asked him if this, in order to grant this subdivision, that they would require a variance. My understanding that is a variance has to accompany the application at the time that it's being handed in. We never received any kind of variance in this application. And again, I'm not going to start issuing variances just so that an application can meet findings.
True, there was not a request for a variance that came with this application. And when it came up with, and this is
because
not
there was
planning and
no
zoning's
requirement in the
recommendation. Planning and zoning
regulations.
just recommended approval. So I'm just giving you my professional opinion, which.
The
Yeah.
reason no variance was offered is because it's not required in the regulations.
Well, I guess Mr. Gersh would disagree with that. So thanks, David. We might be pulling you back up here. Okay. Yeah. Jennifer,
Commissioners.
welcome to the sticky wicket.
Welcome
Right,
to the
yeah.
sticky wicket. And you're going to get my standard response. I don't know without doing research whether the subdivision road standard, the 50-foot with the 16-foot road would apply from where it comes off of Vista all the way to the start of the subdivision or just at the start of the subdivision. And I was just talking with Kurt and we would need to have some time to be able to research that to give you that opinion or not, because I don't know off the top of my head and I don't want to tell you something that's incorrect.
Okay, fair enough. I think that's a fair. Yes, Ms. Fulton.
May I respond briefly?
Sure.
With regard to the subdivision road, there is a bid that's been provided. The City and Planning Office has seen that maintains Section 6 small subdivision process, public access right of way, the minimum 50 that you're concerned about. However, that's within the subdivision. I understand your question to be whether or not the road outside that narrows as it goes up the hill. And I want to point out in my presentation, I indicated to you the easement rights, H.O. McConnell's easement over the private road of Carrie Lynn Lane. The easement rights cannot be exercised over the entire servient estate. In other words, Bacons don't have the right to do anything to that road, that Carrie Lynn Lane. It's a private road. They don't own it. They can't make amendments to it. They can't change it. It doesn't belong to them. The people who are responsible for making the changes are the people who live along Carrie Lynn Lane. Now, bear that in mind. Ms. Bacon is willing to work with those people. And if such an agreement can be reached where there would be bringing the existing road that has been there for in excess of 40 years up to code,
Ms. Bacon's all over that. But that's not the situation, and that's not what you're being asked to decide. My client has no right, no ownership right on that private road to do anything except cross it. Cross the private property, cross the private property along Carrie Lynn from Vista all the way to their driveway. At their driveway, they have authority, and that's where the bid comes in. They have agreed to, and they are meeting every county regulation that exists with regard to the width of the road. Thank you.
Thank you, Ms. Fulton.
Mr. Chairman.
Yeah.
In the hierarchies of law and rights, would you say that louder, please?
No, come on.
In
Neither
the
one
hier-
of us are
No, here
attorneys.
we go. Yes, yes. No, but you don't have to be an attorney to know
I
this.
don't. I don't have to.
In the hierarchies of law, it's a poor lever to say, basically to say that they can't subdivide their property because they can't make the other landowners widen the easement.
So you'd cite your authority on that? What would you point to cite your authority on that? I mean,
It doesn't matter what my authority is. I'll never convince you,
well,
Mr. Chairman.
No, well, you may or may not if you had like some legal
I
precedent or
actually
something,
don't
but-
really understand why there's a predilection for wielding authority. It's odd. For weaponizing authority.
Mr. Richardson, April of 2020,
I
made a
withdraw,
mistake.
hey, I withdraw my motion, Mr. Chairman.
In April of 2020, we made a decision that was incorrect. And the reason I know it was incorrect is because it got overturned by the district court.
But Ms. Bacon
So-
didn't have any representation at it. That's like a default judgment.
Well, whatever.
There was no
reason-
alternative viewpoint offered.
Well, I don't remember reading that in the court's decision. So we want to get it right. April 2020, we know we did not get it right. We didn't, and that's just fact. And it's whether you like it or not, it's just fact. Can we get it right? I hope we get it right. We should do everything we can to get it right. And so if our planner says there probably would need to be a variance, that's an issue for me. If our attorneys say, well, we'd like to study this more to get it right, that's also an issue for me. And so if you want to withdraw your motion.
Yeah, I withdraw it.
Okay, with second agree?
Second agrees.
Okay, the motion's withdrawn. Is there any other motion on the table?
Well, I guess I move that we table this till we get that information from our attorneys.
Second. And then just to there are the road access and then the access itself, right? So there are competing ideas in this room today about whether there is actually legal access or not legal access. And so if we could get that included,
Mr.
I want
Chairman,
to get it right.
We solved the question of legal access. Now we're only at the place where the legal access is wide enough or developed enough. And if it isn't, who has to do that? We're way beyond the actual legal access.
Well, I don't know if Mr. Edwards is right or wrong. He said 5 and 6 does not have legal access. I don't feel solved, right? Maybe he's right, maybe he's wrong. I don't feel that in my mind, I have what I need to say that whether he's right or wrong. And so I remember that, second that.
Yeah.
Is there any other further discussion?
You know something interesting about this?
Yeah.
Mr. Chairman. Likely because of the nature of that development, no one will ever ask for annexation. And it shouldn't be because it's right up against the DOT right of way. And it's a dead end street, not a through street. So the traffic is is limited by the number of lots on it. These things are all known, like there's no controversy here. There's none.
We have two attorneys in the room.
Well, we have an attorney representing a group of landowners who don't want their neighbor to exercise their property right, and they're trying to find any leverage they can to limit that.
Okay, well, we have to act within the law and we should get it right. Any further discussion?
Just a point of clarification.
Sure.
I appreciate a timeline on when we might find reconvene for a motion and discussion on the findings of the town.
Do you have an idea? 2 weeks, a month? I don't know how that world works.
Mr. Commissioner, I believe a month would be sufficient. I don't know exactly when the next meeting is in that time frame.
So the first Monday or the first Tuesday in September?
We can have an answer by then.
Okay. Does that answer it for you, Ms. Fulton? Thank you. To move and seconded, any further discussion? Hearing and seeing none, all those in favor signify by saying aye.
Aye.
Aye, all those opposed?
Aye.
That motion carries. Thank you all. Appreciate the spirited discussion. Learned a lot. I'm looking like I'll be learning some more. So item 11, discuss proposed amendments to the Albany County zoning resolution aquifer protection overlay zone. David.
Yeah, so this is my easy one for today. Aquifer protection. Just joking. Okay, so since the last meeting, well, it wasn't last meeting, July 6th meeting, at that meeting, we discussed some more comments on this draft that we've been working on for quite a while now. And I've incorporated the changes that I understood from the meeting. So I just want to go through those real quick. There was a statement that we discussed about the western boundary inaccuracies. That's not in here. We removed that. We removed the definition of best available technology. That was pretty easy. There was a reference to the city of Laramie's cap that we removed. And instead of that, added language that basically refers to the boundary as being the map. Let me find it real quick. And I'm on page 3. I'm going to use the redlined version here.
Okay.
It says the APOZ boundary is defined on page 129 of the Albany County zoning map book, which the map is in the back of your packet, which is the new map that we've discussed. And I know that we'll continue to discuss. And then added language that allows the city to develop within zone 1. That's on page 6. Develop as in, fix their wells and protect it and those types of structures. So then the next one is the setback. So we talked about the wastewater engineer ability to lessen the setback. So I do want to go over this because I actually made some word changes since I sent this out just to make it a little clearer. So it's on page 11 where the red line starts. So basically it says this setback may be lessened upon approval of the county wastewater engineer. And then I'll skip to the red line. This documentation must be provided by a professional engineer geologist licensed in Wyoming and should include the following. And then I modified this one a little bit to say evidence that no other location exists on the property that can meet the required setback standards. The second would be evidence that ensures no significant threat to groundwater will occur due to installation of the proposed wastewater system. And then if recommended mitigation methods needed to protect the groundwater are installed. And e.g. installation of advanced wastewater system is defined by the Wyoming Department of Environmental Quality. So there's that to hopefully address some of the concerns that we discussed. And then the last thing was we removed the APOZ development process in its entirety. And then on page 11, I think it is, I'm looking at the right. Yeah, so in page 11, I changed the first part of the site-specific investigation. I added A, and it says, an SSI shall be required with applications for a zoning certificate, zone subdivision permit, conditional use, or zoning change. Zoning certificate applications requiring an SSI shall be approved by the Board of County Commissioners. So that addresses the removal of the permit part of it, and it adds what permits we will look at. And then it also requires zoning certificates that require a site-specific investigation to come before this board so you can review them. So that's what I did. And we can continue this discussion or whatever you'd like to do. So,
Thanks, David. I appreciate it. Commissioners.
Yeah, thank you, David. I do feel unfortunately that we might need to go through this sort of page by page, and David, I can get you changes as far as punctuation and all, but
Sure.
I think, may I?
Sure.
Thank you. If I can start on, let's see, page 3, I think in our editing, we got a little excited and took out some stuff that actually needs to be in there.
Okay.
I'm referring to page 3 when we actually talk about the Aquifer Protection Overlay Zone and its establishment. I believe you start right off, David, with this is section, I can't tell if that's 4 now, or I guess it's 5, Aquifer Protection Overlay Zone established. You struck everything out and started at the 8 pause boundaries defined on page 129. I think we still need that explanation up in the first paragraph underneath this, that there is established within the unincorporated area of Albany County an Aquifer Protection Overlay Zone. The 8 pause is the area where the upper, all that, do you see that?
Yeah.
I think that still needs to stay in there.
Okay, if I struck that, then yeah, we can definitely,
Yeah,
leave that, so,
and then it would proceed with where you started, the 8 pause boundaries defined on page 129. So I just want that defining paragraph put back up there.
yeah, and that makes a lot of sense. So
Yeah.
if I did remove that, I apologize. So,
No, that's okay. I think we got a little zealot here in our trying to trim this down a bit. I don't know. Let's see, page 3, section C. Let me make sure. I'm looking at the clean version, I think, David. Anyway, page 3, section C, number 2, you have, if there's a study being done, it shall be reimbursed. It should read, shall be reimbursed to the county by the exclusion applicant and not to the exclusion applicant. Right? That's a big
probably,
difference.
yeah. Yeah. So where is it at again? I'm sorry, I'm trying to.
Let me find it on the, I think I was looking at the clean version, so let me scroll down to that, David.
You said
I said, page
5
3, section
C.
C, number 2.
Oh, okay. Reasonable cost professional consultation with the county shall be reimbursed.
Yeah, it says shall be reimbursed to the exclusion
Oh,
applicant.
yeah, okay.
It should be by the exclusion.
Bye. Okay.
And we could put it, be reimbursed to the county by the exclusion applicant if need be. Then let's see, page 3, the clean version again, paragraph 5C. I think, let's see. So evidence shall be based on publicly, I'm sorry, Dave, I need to find it.
Oh, you're fine.
Okay, evidence shall be based upon publicly available data and provided by professional geologist or engineer with appropriate expertise. I think, oh, sorry, that was just a typo. And I told you I would get things to you as far as typos.
Okay, perfect.
Page 10, the clean version, paragraph B, I guess it would be 6. A determination of any necessary mitigation measures or setbacks as a result of features and conditions identified as identified by 3 above. I don't want to just be hanging out there. Let's see. I don't know if as a result, features and conditions as identified in 3 above. And it should be or conditions. Are you finding me, David?
Yes, features or conditions.
Features or conditions as identified in 3 above or by 3 above. I.
By 3 above?
Mhm.
Okay.
Page 11, I think we can eliminate it, hydrologists, because hydrologists are not licensed as such in the state of Wyoming. So it can just be left with the professional engineer, geologist, or other qualified. This is page 11 in the clean version. Let's see. Because on page 16, clean version, David. Oh, maybe not. Maybe it's the red version, since there is no clean version of 16. Anyway, I think we whacked it away again too much, and because we whacked away the APOS permit section. So I do think we need some kind of modification. Section. Let's see. So page 60 at the bottom there, where it says modification, and it's all taken out. If we could put modifications, applications for modifications to any APOS development shall be submitted on a form supplied by the Albany County Planning Office. The application must address how the modification meets the recommendations of the SSI and technical review prepared for the original development. The Board of County Commissioners shall vote on any proposed modification. Because right now we have no way to modify an existing development.
If we're okay with that, would you mind just sending me that language?
Yeah.
Okay.
Are you guys okay with that? Okay. I'm trying not to go through things that I can just send you words. I guess, David, also, since we didn't eliminate, sorry, that we did eliminate the definition of best available control technology. It was deleted back in the definitions, but we ended up not deleting the non-conforming use. I think we do need to have that definition put back in it, because the non-conforming use refers to best available control technology.
Okay. So you want it back in now?
Yeah, sorry.
So, no, I mean, it wasn't I think
No,
someone else suggested removing
yeah,
that.
I asked you to remove it, thinking that we were going to delete the whole section of non-conforming use, and we didn't. So therefore, it needs to be put back
Gotcha.
in. Okay, and I think that's all I have besides just commas and punctuation. Thank you, David.
Sure, Richard. So Commissioners, would you like to approve it today with those changes? What's your pleasure?
Mr. Chairman, by law, this needs to go, we've made substantial enough changes that it needs to go back to the planning commission to satisfy state law.
Yeah. Somebody help me out with that, please.
So this is the discussion that we've had previously, that we're submitting the request to the AG for the formal opinion. But currently it is my belief that it does have to go back to the planning commission based on the way that the statute is written, where it says that recommendations, anybody can suggest changes to any regulation to the Planning and Zoning Commission. The Planning and Zoning Commission then certifies that result to you where the Board of County Commissioners then has the option to either approve or reject, is what the statutory language says. There's nothing in the language that allows for modification. So in the research I did and in the informal conversation I had with the AG that we work with, it was my opinion, and he agreed, that because if changes are made and changes are not specifically addressed in the statutory language, that it needs to go back to planning and zoning for their review and certification to come back to this board.
That presents quite a dilemma because the APOS regulations did not do that when they were redone many years ago. And so they came from planning and zoning. The commission made substantive changes, took it out to public comment, and those are the APOS regulations that we deal with today. That is really difficult to square with that opinion versus whomever was getting that opinion, and maybe they did it wrong. But that allows us to now think, what does that allow us to think, right? If that was done incorrectly.
I was gonna say, and I wasn't here before and I hadn't
Right.
looked into the history of it. So that is news to me, and I'm not certain then how that squares up, other than what's done has been done.
Yeah.
And the question is, how do we move forward correctly?
Yep.
Mr. Chairman,
Yeah.
that means that we've been enforcing a non-legally binding set of regulations for all this time, since 2011.
If it, I'm not sure what that means, but if that's what the assertion is,
So I'll just add a little bit to that. So if that's the case, we did go through a zoning update at the same time, which the Aquifer Protection Overlay Zone was part of that. And we did go through the proper channels and do the proper, everything was proper with that. So I think they're enforceable. Just want to bring that up.
yeah. That would be nice if that were true. And I hope it is.
That's good.
Yeah, but this is where some of my hesitation on this whole conversation is. So we can create a document today. And it's your assertion that we have to send it to planning and zoning. We don't have to agree with that assertion, of course.
Correct.
And then we'll do what we will, or we can agree with it and send it to planning and zoning. Well,
I guess my question is, Jennifer, when does that end? I mean, how many rounds can you go back and forth here? Because to me, that's implying that the P&Z has more authority and not being an elected board than the commission, which is an elected board. They're just a recommending body.
Right.
I know we can make some changes. So if they make substantial changes and we don't like those, we decide to make substantial changes. This just goes back and forth forever.
In theory, yes. Which is a terrible answer,
Mhm.
but I think in theory, yes.
This gets fixed at the legislature.
I agree. And
We're subservient to the legislature. We can't fix it just because we want to.
part of it is when that planning and zoning board was created under the statute takes part of the authority that the commissioners had, transfers it to the planning and zoning board to say, in recognition of the fact that we don't have time to do all of this all the time, we're creating this board to go through all of this, make their recommendations to us. And then if we want, you can approve or deny whatever recommendations comes out of planning and zoning. And if you don't like what comes out, you can then kick it back and make them rework it as well.
that is not the only, I got to tell you, I've sought outside advice on this, and that is not how they see it.
Okay.
So, and I know
That's
this, there's nothing to, everybody can disagree, right? And,
Sure.
and so I'm not sure if this is a good law, a bad law, or whatever. But the recommending piece for me is, I remember the statutes being recommending. At this point, it seems to be authoritative. If we are to make changes, and then they either like or don't like our changes, it seems to be recommending no longer fits. It needs to say they are the powers of planning and zoning. Might be the case, right? I don't know. There might be laws that are bad. We all know that there are. But it seems to me pretty circular on this. And so.
Mr. Chairman.
Yeah.
The reason that it has to go back to planning and zoning if it has substantive changes is because then it has to be recertified for publish, for public notice and publish in a public hearing. In other words, the public process has to be done over again because the changes are enough that it has to go back for public comment one more time, the 45 days and all that that's mandated in statute. So if we just changed punctuation and spelling and, things like that, that's not substantive change. But if we do as much as we've done, then we have to take in openness and transparency and legal process, we have to put it back out there for public comment.
Granted, we're not saying we're not going to do that. I totally agree with that. I'm thinking, why do we have to have the step that it goes back to P&Z first before it goes out to public comment? I'm willing
That
to
would be
dig
a
all
good
that.
question for the legislature.
And that is the question that we're asking the AG.
Yeah.
I actually would like to vote on this today because it won't be legal and I don't particularly like it. So I would actually like to vote on it today.
Well, then you need to make the motion.
Okay.
All right.
I move that we, you could, I'll second it. You're the one who had the changes.
Motion.
Okay.
I'm not ready to have a motion on this.
All right. I have no more comments.
Okay. Commissioners, would you like to send the changes to David? Would you just like to approve them? And then we'll get an AG opinion, send it out for 45 days and head down the process? Or do we get the changes done, send it back to P&Z? What is your pleasure? I'd like to do something.
Well, I have every intention to get the changes to David one way or the other because there are changes.
Do we want to
that are
table it
required.
to the next meeting? What would you like to do? Yeah, David, please.
Well, this was a discussion item, not an action item, so.
I mean, I would like to see if this is what you guys are comfortable with, at least prove the changes. And then you guys can determine where they go from then. And we just say, this is what we're working from, whether it's just go back for 45 days or whether it goes back to the Planning and Zoning Commission or whether you send or, wait for the AG opinion. I think that's in your area, attorney's area. But if we could just at least prove these and call this good, that would be at least a place to start. And then we have a document. I could get it put on the website and those types of things for people to start looking at too. So.
Okay, so I guess it is a discussion item. And do you have any changes other than Commissioner Barros?
No, I mean, I don't think that there's a motion required. I just think that the changes that are suggested would get, at some point, a document has to come back to us in final form.
Yeah, I can.
Right.
David, can you get that to us like in 2 weeks if Commissioner Ibarra gives you the language?
Sure.
Can we put it on the next one and not as a discussion item, as an action item?
Sure.
Thank you. Appreciate it.
Thanks, David.
Awesome. Okay. Item 11 is done. Item 12, acknowledge receipt of the letter of resignation from Daniel U. Mcgregor, Director of the 7 Mile Water and Sewer District. I guess that letter is pretty self-explanatory and in our packet. I'd entertain a motion to acknowledge the receipt of that letter.
Mr. Chairman, I move that we approve item 12 as presented.
Second.
Moving second, any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. Motion carries. And thank him for his service. I appreciate that. 13, update the board on the sheriff's drug testing policy. I see the sheriff and I think I see Christina. Who would like to go? I thought Christina on the docket, but
Yes, I'm here. I'm just upstairs. So we are not making any significant changes to the handbook or his internal handbook. But we are moving forward to further include every member of the sheriff's office in the random drug testing policy. So it used to be that it was sworn officers only, but we have included non-sworn and sworn officers in their random drug test because of the nature of the duties of the positions within his office. There is no major change to the handbook. Actually, there is no change to the handbook because the handbook already states that we are drug testing everyone in the sheriff's office. Under former Sheriff O'Malley, he chose not to do the non-sworn individuals, and Sheriff Appelhans has chosen to do everyone. So we just wanted to let you guys know that we're going to make the change, but there is no change to the handbook.
Commissioners, any questions?
Oh, I also forgot to mention, we did notify all of the staff. So they've been given notification that everyone will be included in the list and that it'll start for Q3 of this year.
And I'm sure that's in keeping with the policy and updating and all that's the regulations, just to make sure.
Correct. Yep.
Awesome. Any other items? This is just an update. Doesn't appear like we need to do anything. Thank you for the update, Christina. Thank you, Sheriff. Item 14, present for approval contract between the Board of Commissioners of the County of Albany County by and through Albany County Commissioners and Albany County branch of Big Brothers Big Sisters for diversion services in the amount of $42,489 to provide diversion services to at-risk youth prior to involvement in juvenile court through the creation of a diversion program. Bailey, good morning.
Good morning, Commissioners. This agreement comes from our VOA grant, our Volunteers of America grant, that's split into diversion services with Big Brothers Big Sisters, juvenile housing in with either Laramie County or Natrona County, and then some electronic monitoring. So this is just that piece of the grant. And I believe Steve's online if you guys have any questions for him.
Any questions, Commissioners?
I have none.
I'd entertain a motion for item 14. If you have it.
Mr. Chair, I move that we approve item 14 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye.
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 Aye, all those opposed, same sign. That motion carries. Steve, thank you for being involved in this critical piece of our county and the juvenile diversion program. I so do appreciate it. Thank you. 15, present for approval memorandum of understanding between the city of Laramie, Wyoming and Albany County, Wyoming for mosquito control surveillance services and reporting activities as required under the Emergency Insect Management Program grant. Bailey.
This is pretty much what your agenda item says. With our grant agreement with the state, we are required to do surveillance and monitoring. The city thankfully is able to do this for us, so we pay them a fee to be able to get all the data we need for our grant.
Commissioners, any questions? And entertain a motion for item 15 if there are none.
I move we approve item 15 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries. Item 16, present for approval, temporary contract between the Albany County Sheriff's Office and Tracy Kazi to maintain current medical services at the Albany County Detention Center beginning August 1st, 2021 and ending September 1st, 2021. Sheriff, good morning.
Morning, Commissioners. This is just a temporary contract to administer medications and then also transfer any inmates that have additional medical services to IMH as Core Health gets ready to implement their contract September 1st.
Commissioners, any questions? Entertain a motion for 16, please.
I move that we approve item 16 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye.
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 Aye, all those opposed, same sign. That motion carries. 17 has been moved.
Thank you.
Item 18, request $100,000 for the Laramie Regional Airport with funding to come from the Albany County Economic Development Fund. Tracy, Good timing. You must have been paying attention online.
I was paying attention online. Good morning, Chairman Gosar and Commissioner Richardson and Ibarra. I have my Laramie Regional Airport Board Treasurer hat on today, but also my County Treasurer hat on as well, because in this request, I worked with Jackie and we determined that there was funds available and already appropriated in the Economic Development Fund. The Laramie Regional Airport, for whatever reason, did not request any money when they have previously annually requested $100,000 or close to. And we would like $100,000 this year. So it is budgeted there. If you choose not to take it there, then we would have to amend the budget and find another source to fund the airport.
Commissioners, any questions? And just to let everybody know, there was a change in management at the airport
Yes.
between the budgeting process and now. And so that,
Yeah, I think it was an oversight, honestly, between Mr. Skinner retiring and Ms. Terrell taking over and everybody trying to learn new things.
okay. I'd entertain them.
I was just gonna say, I agree with that. I think that when you're brand new in a job and maybe the template, it's not boilerplate what you're looking at, it's hard to build a budget without knowing all the ifs and thens and the wheres and whats. And I think that's what happened. Do you agree?
I would agree.
All right, I'd entertain a motion for item 18 to approve the request.
Mr. Chairman, I move that we approve item 18 as presented, granting $100,000 for the Laramie Regional Airport out of the Economic Development Fund.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries. Thank you,
Right.
Tracy.
Thank you all.
Appreciate it. Present for ratification, July 27, 2021, letter from Albany County Emergency Management Coordinator Blake Halsey to provide 90-day notice to terminate EMA's lease of office space at 2020 Grand Avenue, Suite 421. Blake, good morning.
Good morning, Commissioners. Yep, this letter is to move out of the space that we were in 2020 Grand and move into the Emergency Operations Center at Fire Station number 3. Save us some money on grants, and it just makes more sense logistically. So,
Any questions, Commissioners?
None.
A motion for 19 would be great, please.
I move that we approve items 19 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor, please signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. Motion carries.
Thank
Thank you.
you.
I appreciate it. 20, present for approval memorandum of understanding between the County of Albany, Wyoming and the City of Laramie, Wyoming for technical update of the Casper Aquifer Protection Plan and review of aquifer protection measures.
Good morning.
Good morning,
Chairman
Jennifer. Thank
Gosar
you.
again, and Commissioners. This is the MOU with the city that we discussed previously, and it is to hire a firm in conjunction with the city to review the Casper Aquifer Protection Plan and suggest any changes to that plan. The copy you have in front of you has some dates that were changed from the one that was published in the packet to move those dates backwards a bit and up to align with what you, Chairman Gosar, had said was actually agreed upon and was missed initially. So that change has been made in the copy that's in front of you now. And I would just note that the maximum amount to be funded for this project is $400,000, of which the county's responsibility would be half of that.
Jennifer, thank you. And my mistake and my oversight. Sorry about that.
Oh, no, it's okay. I just wanted to point out.
Yep. But thank you for changing the date so quickly. Commissioners, any questions?
Questions?
I have one, and it's for Jackie.
Okay.
I don't remember 200,000 being in our budget, but I'm guessing that we would have to amend to spend that. Is that, I mean, if it's within the fiscal year. It's funny, but anyway, that.
You give me a chance to look, to make sure that that amount that you're referring to is in fact what's in there.
Oh, but I think that the decision today isn't dependent on that. But that was just, I guess I'm asking if it's there or if we're gonna have to amend at some point to take care of that.
I believe it's there, but I want to double check.
Okay,
Give them a chance and I
Yeah.
will get back to you.
And then there's an opportunity, depending on how we read ARPA funding, if this could be fitted under that, fitted, wow. It could fit under that. My grammar is going. So, but I don't know. I don't know if it will or it won't. But in a nice segue, we'll be having a meeting in August to decide that because we have to come up with a report by August 31st that details what we're going to plan so that they can see that we're planning to use ARPA. Doesn't have to be, hey, there's 50,000 and 50 cents to this, but just kind of these are the projects and these are the guiding principles. Is my understanding. Yep. Sure. I'd entertain a motion for item 20, please.
Mr. Chair, I move that we approve the MOU between the county and the city for the technical update of the Casper Aquifer Protection Plan.
second,
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
aye,
Aye, all those opposed, same sign. That motion carries. Thank you. Present for approval contract, item 21. Present for approval contract between the Board of Commissioners of the County of Albany, Wyoming and the Albany County Branch of Big Brothers Big Sisters for aftercare support for IJTP participants in the amount not to exceed $5,000 annually. Rebecca, good morning.
Good morning. Yeah, this is our aftercare and supportive services for the juvenile drug treatment program.
Commissioners, any questions? I'd entertain a motion for 21, please.
I move that we approve item 21 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye.
Aye.
Aye,
Aye, all those opposed, same sign. Motion carries. Item 22, present for approval contract between the Board of Commissioners of the County of Albany, Wyoming, by and through the Albany County and Prosecuting Attorney's Office and Greater Big Brothers Big Sisters for juvenile prevention and diversion services from July 1, 2021 through June 30, 2022, in an amount not to exceed $31,000. Jennifer, thank you.
This is the amount that was discussed in the budgeting process to replace the funds that were previously going from the CJSB to diversion. So this is the contract. And to my understanding, it was included in the budget. But this is the contract to make sure that we get those funds paid to Big Brothers Big Sisters for those diversion services.
Commissioners, any questions? Entertain a motion for 22, please.
I move that we approve item 22 as presented.
second,
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
aye,
Aye, all those opposed, same sign. That motion carries. Steve, you're making out good this morning. I know it's buying lunch. Item 23, present for approval for Albany County Public Health to be the sponsoring agency of the Community Vaccine Incentive Program. This supports Resolution 2021-024, supporting COVID-19 vaccination initiatives to achieve a vaccination level of at least 70% in Albany County. Melanie, good morning. Thank you for waiting.
Hi, good morning. So this is very simple. We've been a part of the Vaccine Incentive Committee, and they have asked us to be the sponsoring agency to collect funds that might be donated towards the incentive project. So what I need permission for is to put those funds into our bank account and then write a check to the treasurer, and that revenue would go into, we have a line item called the Friends of Public Health account where we used to put donated funds. And then we would then either voucher, I guess we'd have to voucher out or pay for incentives through that funding, if that makes sense.
Commissioners, any questions?
None.
I entertain a motion for item 23.
Mr. Chair, I move that we approve
Albany County Public Health to be the sponsoring agency of the Community Vaccine Incentive Program.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries. And just to let you know, next in 2 weeks, probably be bringing an appropriation for this body. The city is going to be putting money towards the incentive program, and it'll be for everybody who is vaccinated and will be getting a vaccination. I think the county, in my opinion only, that we should be matching the city up to a certain point. So just to put that on your radar.
Question.
Sure.
That is, can we use ARPA or some sort of COVID money to make the match? It would seem appropriate as opposed to general fund money.
Yeah, I think so. I think there's money in the ARPA for COVID-19. I can't remember what the wording is exactly, but that's a good thought. All right, item 24. Then for approval, a contract between the Board of Commissioners of the County of Albany, Wyoming, by and through the Albany County Integrated Juvenile Treatment Program and Bennett Law Group, PC, for attorney services to participants in an amount not to exceed $4,800 annually. Rebecca, again, thank you.
Mr. Chairman, Commissioners, this is just the law contract attorney services for the juvenile drug treatment program.
Commissioners, any questions? Entertain a motion for 24, please.
I move that we approve item 24 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries.
Thank you.
Thank you, Rebecca.
Thanks, Rebecca.
25, discuss liaisons for the Urban Systems Advisory Committee. Commissioners, and maybe David, you can help us a little bit, please.
Yeah, so Mr. Chairman, Commissioners, so there's 3 appointees, I believe, from the county that are on the Urban Systems Advisory Committee. Mr. Richardson is one of them, Rob Fisher, and then Alan Frank was the other one. So at this point, they need another person to fill Alan's space where he's no longer with the county. And so I actually sent out an email trying to get, solicit some people that may be interested, and didn't hear anything back from anyone. So at this point, the 2 people that come to mind, no. No, I would do it, but I'm more of a liaison. I'm there for staff help. But Jory Hunverzot, who's my addressing coordinator, who is involved with addressing roads, those types of things. I think that's appropriate. The other one would be Karen from the assessor's office. She's our GIS person and is also involved with roads and those types of things. So that would be my recommendation if we were going to go ahead. And I talked to Jory, but I don't know what Karen thinks about that. So you might want to, if you want to go that route, I might want to talk with the assessor's office and Karen to make sure that would be okay. But those would be the 2 that I think kind of fit that position.
And GIS is helpful in that role, or does it not come to play in it at all?
So it's not, we don't really need a GIS specialist, the person in there. I mean, the GIS is done either by like the city staff or YDOT staff. Usually that's only comes in when we're looking at maps. So what this committee does is there's basically a couple of maps that they've created, and then they get funding and have a priorities list of what to build, and there's different roads on these maps, and they have to be on their maps basically to get funding. So that's what the maps are kind of their plans to show where things are going to go and what roads we want to look at. And right now the big top priority is the Bill Nye road. And so that's on there. And so they basically pick a project to put on the top. They collect the money for that over the years as it comes in, and the city and county kind of match that and then eventually move forward with the project. But GIS doesn't really, there's not a whole lot that they have to do. It's just more of a knowledge of roads and the road system in and around the city is more the knowledge base that you need to know. So.
Chair, can I just,
Sure.
You're our rep on here, so do you have preference as far as who the work and who would be best to serving?
Do you know what's interesting about this, right? So there's lots of people at the table. And I think that the funding, it's federal Department of Transportation or federal transportation money that there isn't enough of, and it takes a long time to accrue enough to get anywhere near doing a project, right? So basically, this group meets not very often because there's not a lot of change happening, right? I mean, and I think that the money is only really used for arterials, you know, for big conveyances, not, you know, local streets or anything like that. So, so when you think about it, if I remember right, Bluebird is probably number 2. And Bluebird is a segment of Bill Nye, right? And I think ever since the high school was built, now there's enough traffic that that it really challenges Boulder Drive and Garfield. So that's how it got into that place. And if you look community wide, you can't find a transportation deficiency or need like those two. I don't know what the third one was. Maybe it was Skyline. Was it Skyline? I can't even remember. But the point is, I don't know if it matters. You know, there's enough minds in that room, enough rules with the money, and it moves slowly enough that it's not really controversial. You know, like the notion that Bill Nye needs to go through to 15 or further, you know, that's just a given. So the question is, how long can we tolerate our current transportation situation and financial situation, and can we make those things converge? And it becomes, so it's just a big slow motion tennis match. And I think that we only prioritize 3 projects. And then we basically, I don't know what the need is for a map, you know, but apparently somebody at the federal DOT likes maps with a highlighted section of proposed road, right? Rather than a legal description or something. But, you know, we all know what it's talking about. I guess if we were somewhere else, maybe we would want to see a map. But it's just basically that. I wish that there was more money and that more could be done, because then it would get interesting and exciting. You know, if you could do 3 projects in the next 5 years, then you'd really get to think about what was, you know, with the city and the DOT, what ought to happen and how and why and what.
So you don't do any further action until you finish the one project you dedicated funds to?
Well, so there's, the committee basically prioritizes. But when you figure the funding, we're talking like a 15-year priority schedule, right? So probably the only one that really matters is the number 1, right? And at this point, it's Bill Nye from Vista down to at least 15. I don't know if it's all the way down to 3rd Street. I can't remember.
Mr. Chairman, this is Rob.
Hey, Rob,
Yeah, it's basically the priority is from the school down to 15th Street. And then number 2 is Bluebird. And number 3, I believe, is from 15th Street on down to 3rd Street. They do, and Dave can attest, that at the last meeting, they are wanting to move Bluebird down to 3rd on the list. So you do have to pay attention to what they are wanting to do there. Just a little bit of history here. I want to give you guys, there's 9 people on the board. 3 are appointed by the city council. 2 are appointed by the Board of County Commissioners. 1 appointed by the University of Wyoming. YDOT has 2 representatives. 1 appointment by the Laramie Traffic Commission. 1 appointment by Albany County Planning and Zoning Commission. 1 appointment by Laramie Planning Commission. And then the last appointment is an at-large appointment appointment that is concurrent with city council and board of county commissioners. Each member serve a 2-year term.
So I guess, it's kind of on the coalition of the willing, and in light of the fact that there might be some infrastructure being done at the federal level that might bring some money, maybe there is the opportunity to do more stuff. So who usually sends out these letters? Does the commission send out the letter? Maybe we could ask them both, and if somebody wanted to volunteer, that would be great. And if somebody didn't want to volunteer out of Karen and Jory, maybe we could cast a wider net. And Kurt might have a longing to be on the urban advisory system. You never know, right?
Well, it wouldn't occupy very much of your time.
I kind of think that it doesn't hurt to have somebody from David's office especially like before it was Alan who kind of did addressing and GIS. So at this time it would be just somebody that does addressing, but they have an idea of what's happening surrounding the urban system.
Mr. Chairman, in light of the fact that we have talked to Jory and we have not talked to Karen, it wouldn't be very nice to assign Karen that responsibility without talking to her first. So I'm curious what Jory's thoughts were on the subject.
He was fine. He's like, whatever. So he's willing to do whatever. So, but I'd be happy to talk to Karen too and see what she thinks, and I can discuss between the three of us and just come up with a name and bring it back if you want.
That'd be great. Thank you. Yeah. Yep. Thank you. Thanks, Rob. I appreciate the background.
One last question to hear on this. Are you willing to trade liaisons for something not so boring? I'm teasing. I'm totally teasing. It's just
actually one thing that's interesting is I always thought that Bluebird should be number one. And the reason is that road, it's really short. So that makes it affordable because it's short. Also, it's already in existence. So the safety issues exist because there's already a road there that's probably not adequate. So I never could understand prioritizing building something across prairie where there's no safety issue.
Correct.
Compared to building something where there's lines of sight issues and, no pedestrian walkways and all that kind of stuff. But that position didn't prevail. And I actually am fine with it being in second place. Third place starts to frustrate me because then I start thinking that the city wants the money to improve its infrastructure more than it wants to deal with safety, right? So the Bluebird project is one that if it was first, could get knocked out pretty quickly and deal with actually some pretty substantial safety issues there just because of its narrowness. Right? So anyway, it's cheap, inexpensive, and important, urgent. So yeah, but those are the projects and they probably won't change for
15 years.
8 anyway. I mean, I don't know. I think developers have to build the internal streets of their development and the infrastructure, water, sewer, all of that kind of stuff. But I don't think you can make a developer build the big arterial outside the development, right? And so that's kind of what this is for. It's challenging to build arterials or gathering streets. It's hard to figure out who is supposed to pay for them or how they're going to pay.
Item 26, acknowledge receipt of the letter of resignation from Kristen Landreville from the Albany County Public Library Board and direct the clerk to advertise the vacancy. I'd entertain a motion for 26, please.
I move that we approve item 26 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye. All those opposed, same sign. That motion carries. And Kristen, thank you for serving on that board. It's important to have people, and that's my neighbor, so she does such a nice job. 27, present for approval, salary increase for IT director. Christina. Good afternoon now.
Good morning, or yeah, good afternoon, I guess it was noon, huh? So this is in front of you today. It was missed prior to budget. And so the way that it's worked in the past is every year department heads get a $5,000 increase until they reach $85,000. I missed Adam's prior to budget, so it never got put into his budget. And so the request that you have before you is actually for 6,000. We did a wonky thing last year and only gave him 4 of the 5,000. And so I wanted to just do the 6 to take him to 85 instead of 84,000. But the reason that it's in front of you today is because I missed it on budget, it will require a budget amendment at some point. Otherwise he will be negative in his salary line items. So it's nothing out of the ordinary as far as his increase goes. It's just in front of you now because I missed it at budget time.
Commissioners?
Mr. Chairman, I move that we approve item 27 as presented.
Second.
Moved and seconded. Any further discussion? Jackie, would that money come from the commissioner's budget? Where would that?
It's going to have to come from the business budget in your county commissioner budget where we appropriated $100,000 for things like this. This has nothing to do with this particular motion, but it's really, really difficult for Tracy and I to be prepared for any recommendations when nothing is vetted to us beforehand so that we can be prepared. I realize we get the agenda and we prepare it in regards to your question. The reason why I wanted to ask Tracy is for the $200,000 because my mind immediately went to steps using those funds, but it can't because of the language on the ballot.
Right.
So it will have to come out of ARPA funds in order to appropriate the $200,000 for the MOU contract with the city of Laramie. And so we are beginning to start as early as we are in the budget to make so many amendments. Want to make sure we've got the funds to be able to do what we're doing. Because within the last 2 meetings, we're talking about approximately in the county general fund, maybe $406,000 that we had no idea and didn't get a chance to that. So nothing to do with this agenda item, but in the future, maybe this is when the governance committee comes back and we try to develop that committee where the chairperson, the treasurer, and I sit to look at these so that we have funds available so that it gives us a great paper trail in the minutes for the auditors and it provides transparency. So just sorry, I know you're okay off of this, but that's where where these funds come from.
Yeah. And meeting can be done over email as far as I'm concerned, if you guys feel comfortable with that or in person. Sure. Anytime we need to do that, let's do that. And so that everybody feels comfortable and we have an audit trail that is clear. Okay.
Yeah, what's interesting about that is that it was really good policy, right? If you have something that comes on the agenda that's going to require funds, it probably shouldn't come on until the funding source is identified, right?
Yep.
And so we just had a couple things come on that somehow that wasn't done. And it's good. It just makes it easier.
And I'm not blaming anybody. I just think it's a good process for us so that we're all on the same page. And
Jackie, I have a question for you in regards to my agenda item. Could the funds come out of the salary reserve? Because we use that money to fully fund all of the positions. And so I'm curious if we have the money there to cover it versus coming out of the commission budget. It doesn't matter to me. It is my fault that I missed it at budget time. But if we have the salaries or funds, could it come out of there versus the commission? That way, if you guys need to use that money later for something else, it's available.
It could, but then it's a transfer from the salary reserve to the general and then the general to the IT budget, whereas this will be a straight transfer from the general fund to the general.
Okay.
And I would like to, I see Tracy there waving her hand. We like to confer with each other because believe me, I don't by any means believe that what I say is the way it should be, because this helps us do what needs to be done the right way.
Right.
Tracy, do you have, could you join us?
Yes. So my addition to what Jackie was saying is at the end of the fiscal year, and unfortunately I can't give you the exact number because our accounting software is down at the second, but at the end of the fiscal year, we ended up with more cash than what we applied in our budget. Therefore, we got the cash on hand. So when we do that amendment, we can use that cash on hand in the general fund.
And just while I've got you, does it make sense to do this after the agenda meeting? You, me, and Tracy to sit down after the agenda meeting and make sure all our ducks are in a row? And is that something we can just do? Okay.
That works for me. And I think it'd be great because then it's so hard to have all the numbers and the funds in your head when you're put on the spot.
Super. Let's do that if that's all right.
Thank you.
Yeah.
Appreciate that. Thank you.
Yeah, thank you.
Okay.
No,
Thank
you're
you
just
for
fine.
allowing me
No,
to-
you're fine. Well, and it brings up a good light. And what this particular case was my fault because it did not make it on for agenda. But if it is approved, I do have a salary authorization form. It's actually up in Amanda's office. She has a few for signature, so we can have you guys sign off on that.
Okay, I think it's been moved and seconded. Any further discussion? All those in favor signify by saying aye.
Hi.
Aye.
Aye, all those opposed say aye. Motion carries. Thank you. And
Thank you.
Great discussion and appreciate the better processes coming out of it. 28, request partnership of support for a National Endowment for the Arts, Our Town Creative Placemaking Grant application on behalf of Action Resources International. Gail, thanks for staying with us, going through the fire drill now.
My
spending
pleasure.
lunch.
Thank you, Mr. Chairman, Commissioners Ibarra and Richardson. I'm always in awe when I sit at these meetings. I'm so grateful that there are people like you willing to do this really important and complex and not always exciting work. So thank you for that. I'm here as CEO of Action Resources International, which is the 501c3 umbrella organization for Feeding Laramie Valley, which you're probably more familiar with. Action Resources International has now put on 4 annual events that we're calling the Higher Ground Fair. And the Higher Ground Fair is very unique just about anywhere in that we bring together a great mix of participants and fairgoers by connecting everything that is traditional and innovative in the Rocky Mountain region, from music and the arts to agriculture and gardening and social and health and wellness community interests across the board. So we include fiber arts and traditional arts, quilting, as well as innovative shelter and energy things. I sort of think of it, for those of us of a certain age, remember the World's Fairs from way back when. It's a miniature nod to that kind of thing. And as a result, we've found just an amazing mix of innovative and often underserved and hidden voices. So we've presented, in terms of the arts alone, the Wind River dancers come and perform every year. We've had the Black American West Museum and Heritage Center has come and presented their reenactment issues. We also have hands-on workshops around all of those matters. So it's a very exciting thing. And for the first time, there are a number of grants that are coming out that from the arts
communities that and agencies, and in this case, the National Endowment for the Arts, that are looking for precisely this. So they're looking for ways to bring the art, to integrate the arts and humanities, and in this case, specifically the arts, into community efforts that are also looking at things like food security and how are we going to do this kind of work and bring communities together using the arts as a way to raise awareness and to help people make connection. And that's what we're finding. So just as a quick example, when we've had the Wind River Dancers, and then we also have a number of displays from both the Eastern Shoshone and Northern Arapaho tribes there. We have foods from there. We have all kinds of art exhibits from there. The first couple of years, that was one of the greatest attended events was when the Wind River Dancers were performing. But what they've told me, and the lead singer of the dancers told me, is that people loved it, but it wasn't until the third year that people started coming up and talking to them, sitting down and having lunch with them, going out and attending other fair activities with them. So it's taken time, but we're actually building community that's beyond just observing. So the National Endowment for the Arts this year is putting out its Our Town Creative Placemaking Grants, which again is funding precisely this, looking at ways in which integrating the arts helps to strengthen communities. So the other piece of it is that they are requiring that the agency that is doing the arts component of things, which would be Action Resources, also partner with a government agency. And that's where you come in. So we're hoping that the Albany County Commissioners would serve as a supporting partner to this endeavor. I'm applying for a 2-year grant. The other thing that the Higher Ground Fair, it turns out, is doing, we're not just doing the fair once a year. We work all year round, especially with underserved communities, such as the Black American reenactors, such as the reservation, such as local artists and musicians who are just emerging, such as local artisans who can't afford to attend things like the Estes Park Wool Market and larger events that cost them $500 a weekend just to try to show their art, their art wares and those kinds of things. So we spend an entire year helping to develop and helping to support and promote these organizations, and also increasing access for fairgoers. So we brought several buses up from Denver every year where people at no charge to them who want to come see people who look like them, who are performing and who are exhibiting in these fairs, they actually can be part of being a fairgoer as well. So they come up, they get a bus ride, they get food meal vouchers, and they get free entrance into the fair. So we now have diversity, not only in terms of participation, but in terms of fairgoers as well. It's really extraordinary and exciting to see. So we feel like this is a perfect fit for this grant. And by having your support, we meet a requirement of the grant, but it also says to the community that this is a community that's excited about promoting this here. And while we actually have people from all over the Rocky Mountain region attend and perform here, but it's here in Albany County, which is also very exciting. And I will be applying again, as I said, for a 2-year grant at the maximum of what they're offering is $150,000 for the 2 years. It does require a 100% match, which Action Resources will provide through in-kind very easily with the several hundred volunteers that it takes for us to do this work, as well as our existing staff that is being funded through other sources. So the in-kind match will be fairly straightforward for us to provide. I think that's a quick thumbnail sketch of what we're looking for. What will be required of you is actually 2 letters. They need a letter of the highest ranking official of this government agency, which would be you, Mr. Chairman, and also a general letter of statement of support from the Albany County Commissioners
in general.
Which would be
as
you,
an agency.
Mr. Richardson.
Are there templates of
Don't worry,
these
we'll find
letters?
something for you to do as well.
I'm sure about
Yeah, yeah. Will there be templates of these letters available?
Yes, I can provide that and
That is
work with
wonderful.
Jackie if I
Yeah.
need to make the wording fit the way you need it and want it to.
Yeah. Yeah.
And I would be submitting, the first half has already been submitted. It's a two-part submission process. So we're in the works there, so that the portal will open to us next week, and it will be open for a couple of weeks for us to submit. And then also, as I think I mentioned in your paperwork, you have all kinds of materials that I gave you if you're interested in looking at that. Michael Lang of the Wyoming Arts Council has very generously offered to review this proposal. He's reviewed these for the NEH in the past. And so NEA, sorry, and he has offered to take a look at it and help to give input as well. So,
All right, commissioners, any questions, concerns, or I'd entertain a motion?
I just have a question, Gail. So in reading your letter and all, have you already applied once for the $75,000 funds for 2021 or?
no, I have not applied before. And that was actually when I wrote this letter, that was prior to me looking at
The 2-year?
the extent, yes, at the
Okay.
2-year.
Okay,
And I
I'm a
think,
little confused. Where's the other 75?
yes,
Okay.
so thank you for pointing that out. It's timed out.
I'd entertain a motion for item number 28.
I move that we approve item 28 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye. All those opposed, same sign. Motion carries.
Thank you very
Thank you,
much.
Gail.
Thanks, Gail.
Item 29, approved vouchers for July 2021. Commissioners, I'd entertain a motion.
I move that we approve vouchers for July 2021.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye. All those opposed, same sign. Motion carries. Before we go to this next spot, would somebody be able to give me is it a 2-hour that we need? Is it a half an hour for executive session? What would you think? Can we do it right now? I don't want to get in the way of people's lunch.
Half
hour.
I was gonna say, I think it's just general updates for you. I don't think we
Okay.
need a lot of action, so I think probably within a half hour.
Okay, crew, would you like to just press on or would you like to come after lunch?
I would prefer to press on.
Okay, let's do that. And would you like to stay here or?
We can stay here if you want. We can turn off the recording and we're good.
Sure.
I'll go get the other. Okay.
Thank you, Jennifer. Thanks, Ben. Except that we probably have to have the recording on to enter executive session. Hey, Ben, could I have you turn the recording on? I'm so sorry.
I'm happy to make a motion, Mr. Chairman.
Please do. Thank you. Sorry.
Mr. Chairman, I move that we enter executive session pursuant to Wyoming Statute 164405A3.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye. All those opposed, same sign. Motion carries. If you're joining us, we will be stopping the share and then we'll come back and enter the regular meeting. Thank you. Yeah, he has something up there like executive session or there's some hold music or. There we go.
Elevator.
Yeah,
How did you know that existed?
because I remember looking over one day and going, oh, that's pretty fun.
Thank you.
Jackie, do you need me to sign this? This is well done.
Does it sound okay?
You bet. Yeah, this is accurate. Read it real closely again and then.
Yeah, how did we get away from sort of that budgetary screening of items that cost money?
Time, everybody's so busy that, we just, and actually, for the benefit of the sheriff. He didn't know the procedure, and actually, he opened the bid that morning, I believe.
Yeah.
I have no idea it was in the amount that it was in. And so,
Right.
you know, so this is how we educate the broker with each other. So,
Do you know what? I'm gonna guess what happened. So you have the formal meeting where the three of you sit down. But at some point, that becomes cumbersome because somebody's not there or whatever. So then you do it informally. You just check in with each other, right?
Hey, they did not shut off the recording. Thank you for bringing that to our attention. You're welcome. Bye. Bye.
We could go somewhere else.
Just want to go to my office. Legit, is that all right? Oh, that's fine with me. I don't trust all that.
Yeah, Kurt's like, I don't know.
So am I right, Jackie? At some point, it becomes sort of informal, like, yeah, right, and then.
Yeah.
But it's not a fit, you know, like, where do we find the money for this? But it doesn't mean that the chair is included in that conversation.
Well, the chair was delinquent in his duties, so you'd be trying to be
Well,
ongoing.
no, you know, I just, you know, right away when you asked the question, my mind went to spec. We got that money appropriated. But then I forgot the language of that.